Hey everybody, we're really excited today. We're going to be doing an interview with several people that have experience in collections, and that's so important because of the times we find us in to understand this a little bit, especially as pertains to the pandemic and everything else. So I thought it'd be really helpful to share some industry knowledge. First of all, we have here Darren Dowd and Richard Teal. They're attorneys with the Lieberman, DeVoren, and Dowd LLC law firm. And the firm is a full-service real estate landlord and tenant law firm. Did I miss anything on that? I'm sure there's a lot more that could be said. Darren or Richard?
I, Andy, that pretty much sums up what we do. If it's real estate or landlord based legal work, we're going to be the ones who can do it.
All right. Well, and that was Darren. Clearly, that was Darren Dowd, and also Richard Teal is on the phone. Hi, Richard.
Good afternoon.
Hey, welcome. So I'm going to just start right into the questions that I have, and then we can kind of play from there in terms of any useful information that we think that could be really impactful for the people listening here. So how many evictions do you estimate your firm does a month?
This is Darren here. We generally file about 100 a week pre-COVID. So we were in the range of 300 to 400 a month pre-COVID. Once COVID started and the restrictions on evictions began, that number really shrunk, at least for the beginning of COVID back in 2020, and has now been picking back up as the moratoriums start to expire.
Sure.
But generally that's the number. We do such a high volume. We have, a support staff here that handles pretty much all of the ins and outs on the eviction side, from notification to filing to making sure clients are aware of their hearing dates and their move out dates and things like that.
Sure. So how many attorneys do you have working on these evictions?
So our firm is made up of 3 partners. Gary Lieberman recently retired. So David DeVoren and myself, Darren Dowd, are the 2 partners. And then we have 4 associates. And between all of us 6, we all handle eviction dockets at various times.
Okay, that's nice. So do you find that expertise that you have from doing so many evictions, and I assume you have to be, I haven't tried to compare it to any of the other firms that do file evictions or individual attorneys, but I assume that you're at the top, probably 3 or 4 in Cuyahoga County, and perhaps Lorain County as well, in terms of filings that you guys do, right? How does your expertise, how is it helpful when you're going before magistrates and judges that you know?
Sure. I'll let Richard defer and give you some background on, our experience with the magistrates and judges in Northeast Ohio, as Richard is probably at this point in the firm one of our primary eviction attorneys in the local courts.
Okay.
Thanks, Darren, and thanks, Andy. I would say that the frequency with which we're in front of all these local courts certainly gives us an advantage because we have a strong familiarity with the local filing requirements, which are always subject to change, and we keep up on those. And then in terms of the individual courts and magistrates, how they might frame questions, what things typically come up during the course of a hearing. So we're always available to answer any questions, to go over things with potential witnesses prior to a hearing. I think that we're uniquely positioned here to help the client get through both the eviction and the second cause money claims, because of our familiarity with each of these courts and with each of the magistrates, judges that we go in front of, and the different processes that play out in each of the courts.
Mm-hmm. And I might add, if I will, that my experience being in these courts, not as an attorney, but from the property management side, is that in reality, these are little fiefdoms or little kingdoms that are run by the magistrates and judges, and that they have a lot of power because even though they're governed by the rule of law, they can interpret things. They know that regardless of whether they follow the law, this is kind of a common understanding that most people don't really have the resources, or it's not really practical to try to fight any single decision. So understanding kind of the house rules, having a relationship with those who set those house rules makes a difference. It absolutely makes a difference, especially when it comes to being able to advise and help navigate sticky in rocky waters, you know.
Now, I would tell you that the relationship isn't going to garner any type of special behaviors or rulings or any type of things like that with magistrates. But us, like you said, understanding their fiefdom and how they
Yeah.
operate will give you an ability to have a smooth interaction in that court. You know, you could take Cleveland Municipal Housing Court or Garfield Municipal Court, and we know what those magistrates need or look for
Yeah.
in terms of getting a judgment on collection or a judgment on eviction. So we'll be able to prepare clients for those particular courts because, as you said very accurately, each one is its own kind of, you know, fiefdom, and they have their own nuances, and we're in a position to know each one of them.
Yeah. And obviously when we're hiring, when you're getting counsel, you're looking for somebody, sometimes even just to make sure something never happens, you know. You might not want to hear it, but you might be saying, hey, you know what, don't go to court on this one. I already know what's going to happen. Just having that saves a whole lot of heartache, you know, and missed expectations. To have the right expectation up front based on someone who's been there in front of that same person and had multiple histories with them. You know, you understand it. It's not even about influence necessarily, but understanding the situation is huge when you need counsel, which is what you guys are, right?
That's it. That's exactly right, Andy. And if someone came to us with a scenario that was in that realm where we could say, hey, look, if you go to this magistrate or this court under this, you know, reason for eviction, you're not gonna get it, or it's gonna be unlikely that you're gonna get the judgment. Let's then formulate alternative avenues that will get you your end result that you want. It may not be as fast as you want it, but when the time comes, you will end up getting the judgment. That's kind of one of the other things we like to do with our clients is formulate the alternative methods of getting the eviction. You know, especially now in light of COVID and, you know, these large delinquent balances, we've been able to counsel clients on how to get the eviction done in an alternative method that, you know, may have been stopped because of COVID related moratoriums.
For sure. So, could you summarize? This is for either Richard or Darren. Could you summarize the normal eviction process and the stages and how they work and kind of what messes them up? Could you just kind of go over that?
Sure, I'll let Richard give you an idea, background of the eviction process, timelines, and all of that under the guise of pre-COVID procedure.
Yeah, and we'll talk about the post-COVID or how that's changed, but I'd like the general information now.
Sure.
So go ahead, Richard.
Thanks, guys. The vast majority of evictions that are taking place pre-COVID were for non-payment of rent. And the standard process for non-payment of rent is after they have failed to, your tenant has failed to make timely payment based on what their lease calls for and any grace period that's incorporated there, you would serve a 3-day notice to vacate the premises on them. If they fail to vacate the premises or return or tender timely payment in full, then after that 3-day period had expired, that's when you would be contacting our office and filing the 3-day notice. We prepare an eviction complaint.
Could I break in real quick on that? Ask a further question on the 3-day notice?
Mm-hmm.
The 3-day notice, do you guys ever serve the 3-day notice for any of your clients?
No.
Okay.
No. We can assist in preparing that, and we often do, but we don't actually serve the notice. That would be up to the property management company or the owner or a
Okay.
process.
Well, I was thinking of like, say an owner didn't have a management company and don't live in the area. Do you know of like servicing companies or anything like that that can do that?
There are process servers, so you can always give us a call and we can point you in the direction of private individual or
Okay.
company can do that
Great.
for you.
Great. Thank you. I'm sorry.
While we're on that topic, I would note that in many of the courts around here, they require firsthand testimony from the person that actually posted that notice. So when the landlord posts that notice or has someone do it for them, it would be good to have that person available when it comes time for the actual eviction hearing.
Okay.
So after that 3-day notice gets posted, the time period expires. We file the complaint with the court. It varies on the court. It varies on the caseload that they have in front of them. But generally speaking, you're probably looking at a few weeks, roughly 3 weeks before that eviction date gets set, because the court actually then has to go out and issue service of the eviction complaint and the summons to appear in court. And then when the eviction hearing takes place, they're usually very summary in nature. They only take a few minutes. We have one of the attorneys with the property manager or the owner on the line, recounting the facts of the case, which in most cases is when was the rent due? When was the last time you received a payment? And based on them not paying their rent on time, did you serve a 3-day notice to them at the property? What date was that put on the unit? And are you asking to have possession of the property restored to you? If the court finds that the rent was not paid, then typically the standard move out was roughly 7 to 10 days, in some cases 2 weeks, depending on the court and the circumstances involved. But generally speaking, after an eviction judgment, you were looking at restoring the property within a couple of weeks.
Okay. So, I guess we'll move on to the next question. I appreciate the summary. What are the changes now that that we've seen in this process since the pandemic?
Well, when the pandemic first got going, there was the Federal CARES Act, which put a general prohibition on evictions for non-payment of rent on properties where federal funds were being subsidized to the tenant or to the unit or to the building. That moratorium lapsed in July, towards the end of July of 2020. But there is still a provision that was in that CARES Act that requires, when there's federal subsidies, you should be putting a 30-day notice instead of your typical 3-day notice for the non-payment of rent. That's arguably an open question under the law, but to be safe in those circumstances, I think you're probably still better off serving that 30-day notice for the non-payment. After the CARES Act lapsed, we kind of went back into a normal period for a couple of months. However, the Center for Disease Control and Prevention issued their own moratorium that applied to all residential evictions for the non-payment of rent during this period, so long as the tenant served on their landlord a declaration made out under the penalty of perjury that said that certain facts were true about their circumstances, which included that they were making under $99,000 a year, I believe, that COVID and the overarching situation had led to a substantial loss of income or an extraordinary out-of-pocket medical expense, that if they were evicted, they would be likely homeless, and that they had made all efforts to obtain government assistance, as well as trying to make timely partial payments based on what their circumstances permitted. So as soon as the tenant served that declaration, most courts were putting the case on hold until the moratorium expired. which currently, after a couple of extensions here, is set to expire on June 30th. There are several, I should say, federal court cases challenging that moratorium, but at the moment, there has not been a federal blanket injunction that would shut down that moratorium from taking effect.
Gotcha. Okay. So it's been challenged, but it's not completely removed. Can I ask you, is there any way to challenge, since under the laws of perjury, they're making this declaration or statement? And, I assume a lot of people, they just simply, they go in there and like, check. They're not even reading it. Or if they
Mhm.
are, they're willing to easily lie. And then they get it signed and they're like, boom, stop. They're like, haha, is there a way in court to kind of challenge or ask for discovery proof of these declarations?
Andy, every court has handled that process a little bit differently. Some of the courts, you file a motion that asks that the stay be lifted and that we redo a hearing on the issue of whether that CDC declaration was truthful. And in those courts, if you go in and you're able to elicit testimony or establish that they did not make those statements accurately, then they'll allow the eviction hearing to go forward. Some of the courts, until just recently, had been completely putting a stay on the case. But in most courts, there's an opportunity to at least challenge it, whether it's at the first cause hearing for the eviction or through a motion after the stay has been put into effect.
That makes sense. Oh, so I'm trying to think. Has this affected the second cause? So you explained first cause on eviction. Could you mention second cause a little bit, what that is and the difference between the two, and then
Sure.
and then also let me know how that's affected.
Yeah. So most eviction hearing or cases involve two causes of action. The first one is the eviction itself. That's to regain possession of the property. The second cause of action, which a lot of it just gets shortened to second cause hearings, is for the money damages. That would be your claims for unpaid rent, unpaid utilities, property damage that the tenant left behind, and any other costs that remain outstanding after they leave. Those two things in almost every court don't happen simultaneously. You will have a first cause eviction hearing, and if you get possession back, the second cause takes place after you've gone in and you've assessed the condition of the property. You're able to tally up their final statement and their ledger and what they owe. And that's when, at the second cause hearing, we present the damages to try and recover on a judgment.
Okay, makes sense. So what would so obviously the general kind of directives, both from the federal government at the court level, have essentially slowed down or stopped evictions for most reasons. How has the pandemic affect, or the actual getting people moved out? What about that second cause? How has the pandemic affected that?
Well, in terms of the actual case dockets, if the case is being put on hold for the first cause of action to regain possession, obviously the money claims are then getting pushed out. So that's been nuts and bolts logistics. That's been the most immediate impact of it.
Okay.
In terms of the actual judgments, obtaining the judgments, obviously there's been a lot of monetary relief available through these different federal and state relief acts that have been out there. And in some cases, they're able to get the tenant completely current on their rent and get the landlord the money that they're owed. In other cases, they still have a balance that's left over that unfortunately doesn't get paid, and we have to go forward on the money claims. But there have even been some cases there where these agencies that have funds available are able to still step in and assist, even as a judgment is as we're preparing for the second cause hearing, we've had that happen too after the tenant leaves.
Yeah, we've seen
They're able
that
to
for
get a
sure.
little bit of. But in terms of the conducting the actual hearings and that on the money claims, there hasn't been much difference. I guess the biggest differences have just been the timing of the hearing and the money, the sources of money that some of the tenants have been able to find through federal CARES Act money, and different assistance programs that have been made available, as well as stimulus checks and that. So we are
Okay.
seeing recovery from those avenues.
That makes sense. What's the average cost for eviction, and has that changed at all?
So this is Darren. I'll take the average cost that for the eviction. Generally, you have your filing fee, which can range from 110 to 150, even $180, depending on the court. And then you have our legal fees. We generally do evictions on a flat fee basis for the first cause of $150 to appear at each hearing. And then same thing on the second cause, $150 to appear at each hearing. Unfortunately, we have to have a caveat with that. Like every lawyer, there's an exception to every rule, that some cases have to be transitioned over to our hourly rate if the tenant engages legal aid to represent them or a private attorney to represent them that begins to take this case, takes it out of a standard eviction hearing of a summary proceeding and really creates a more involved process that consumes our time and your time more than a standard eviction would. But generally speaking, you're looking at a fairly reasonable rate to do a standard eviction with us. And with the increasing filing requirements and affidavits and things that courts require to get into the eviction court, we haven't raised our rates on the evictions. Our fees have remained the same throughout COVID. And, I credit that to having good support staff that's able to, keep on top of clients and give them the documents they need to get their cases filed. And because of our support staff, we haven't had to increase the legal fees on our evictions.
Thank you, Darren. Is there any way to try and pass off some of that cost to the tenant at all and recover that?
Well, when you recover a money damages judgment on the second cause, the court's going to grant, in most cases, the filing fees that you can recover when you go to actually collect. The collection of the actual attorney's fees is far more limited, and that's not because the court is choosing to thumb their nose at us or anything. It's because the state law, the revised code, actually sets forth that the limited circumstances under which you can pursue attorney's fees against the tenant. And it actually sets forth that that's the case even if your lease agreement says that you can go after attorney's fees. The state law trumps on that one. So in most cases, that's usually not the case. You'll recover your filing fees, but not the attorney costs.
Sure. What about the case of a reinstatement? If we reinstate the lease, can that be negotiated with the tenant?
Yeah, I would say that
After eviction. In other words, like you've gone to eviction. Oh, wait a minute, I got the money. Pay it back. We'll stop eviction. We're going to reinstate this lease. The lease has been essentially violated or terminated.
Sure, that's always negotiable. Those terms you can set forth in an agreed judgment, whether it's on the first or second cause. We have that happen all the time, where we say, if you want to stay in the property, here's what's owed, and it's reflected on your ledger. It's in your lease that this is how we're going to assess these situations. That's between the landlord and the tenant to work out. When you go in front of the magistrate on a second cause after they've moved out, and if they don't appear to try and collect against the tenant, that's going to be dependent on the court as to whether they grant that reinstatement fee as part of the principal amount of the judgment.
Sure. Yeah. That sure varies widely.
Mm-hmm.
we, as a side note, in our lease, we do have a standard reinstatement fee that it's an attempt to mitigate some of the costs. Sometimes it works out, sometimes it doesn't. Obviously, if they don't reinstate, you can't charge a reinstatement fee, but at least it makes it a little more palatable to keep a tenant if they pay a reinstatement fee and mitigate some of their costs in driving you to eviction. Could you chat about the most recent consumer? I believe it's called the Consumer Bureau. What's the name? It's the federal. It's the directive that requires extra disclosure.
So the Bureau of Consumer Financial Protection, Consumer Financial Protection Bureau, recently issued a rule that says that landlords acting as debt collectors have to disclose certain protections that are available under federal or state law regarding evictions. And the Bureau actually provided the brief disclosure statement that they recommend using. Essentially what it does is it points the tenant to the fact that the CDC issued the order that they did back in September. It's been extended a few times, but it points them to that order, points them to the moratorium, and says these are the rights and privileges you may have that you may qualify for under the CDC's moratorium. So that has to be provided at the first eviction notice, which for Ohio would be when you post that 3-day notice to leave the premises. So we've actually prepared a standard revised 3-day notice form that encapsulates that disclosure language while still preserving the standard language that's required by the statute, and doing so in a way that is conspicuous, that's not going to get that notice tossed out in court. The magistrates, especially
Sure.
while COVID has been going on, have been looking at these notices with a very close lens to make sure that they comply with all of the statutory requirements. So that's something that we can provide. We've also been including it on our eviction complaints so that you as a landlord and us, nobody's facing potential liability under the Debt Collection Practices Act.
Sure, that makes sense. And you prepared that for us because you do. I didn't mention it already, but you represent us on majority of the evictions that we do on behalf of our clients. And so let me ask you: is it okay if I offer that 3-day notice you've prepared for us to anybody that would request it?
Absolutely.
Okay, thanks, guys. One other thing that I thought of, in terms of cost of an eviction, you had mentioned that we do have to have somebody, whoever, or generally you're required to have whoever filed or delivered the 3-day notice to be there to testify at court. And so for us, for instance, to go do that, there is an expense that we charge. And so generally, if you're going to have somebody else do that, I just wanted to make a note that would be an extra expense as well. So let me get you to kind of the last question, and then if you have anything if either of you have anything you think should be added, please add that as well. But so with all the issues and getting people out, what are you seeing as opportunities in terms of alternate methods to failed evictions or evictions that are likely to fail?
I'll tell you a couple of things that I've suggested to some of my clients, Andy. And it really, money talks in some of these situations. Cash for keys is always a method to try to induce a tenant to get out during these periods. And sometimes cash for keys even works in lieu of doing an eviction if you have some good faith belief that your tenant will comply in exchange for some money, or in exchange for the return of their security deposit, despite owing you a back balance. I did see clients using that kind of cash for keys method that was generally reserved for banks after foreclosure to get tenants out, used by just standard landlords during the moratorium periods that
Yeah.
they were kind of, their hands were tied and couldn't get people out, they would, offer, return your security deposit, agree to not chase the back rent, and even some instances provide some amount of money to just move, and sign
Yeah.
an agreement to that effect. But those are probably the most reliable
Sure.
alternative methods during this period, is to do that. But
Well, one other thing that I know you've mentioned to us is that if the tenant is for some reason gone into a month lease, we can actually the moratorium specifically is for non-payment of rent. So if a tenant, you can give notice for other reasons for them to leave. Of course, like we've already mentioned, you're somewhat at the liberty of how everything's interpreted by the magistrate or judge. But technically, according to the law, you can still give notice for other reasons that are legal and file eviction based on those if they don't move. Correct?
yeah, that's correct. We would also counsel clients that if they were on a month-to-month tenancy, to terminate the month-to-month tenancy during this period. Unfortunately, some of the local jurisdictions have not allowed that to go through if the tenant was behind on rent. And as we sit here in the middle of May, hopefully by the end of June, this moratorium is expired and not renewed, and we can go back to some level of landlord tenant normalcy.
Right. Well, even without the moratorium, a lot of since the very beginning of the shutdown, it seemed like a lot of the judges, like again, like we already talked about, they just each court did their own thing. They did really whatever they wanted to and what they felt they should do, or maybe perhaps thought was politically expedient. But
I would agree with that statement.
I think that one of the problems that people should understand, and I'd like to know what you think of this, is that from a political perspective, like we deal with a lot of out of town owners, right? From a political perspective, these judges and via the judges, the magistrates are elected officials. And so when they're sitting in front and there's an out of town owner, the tenant is their what do you call it, constituent
Yeah,
constitute
the constituent. Yeah,
constituent. The
That's
tenant
right.
is their constituent, and so there is a political aspect that we have to keep in mind. We'd like it not to be there. It would be nice if it wasn't. We can't go around accusing people for it, but at the same time, that's part of even what we talked about, how you understand the circumstances, you understand the nuances as a professional doing high volume evictions, and knowing these people, you're going to understand and be able to help read that and help us do what we need to do.
I would agree with that, Andy. I don't think you can look at this type of practice of law and this type of work in terms of eviction work and dealing with local courts and removing their residents from their properties. It's never a good thing. No landlord wants to do it, but you can't look at it without understanding the whole big picture of everything that's going on. And you're right. At the end of the day, that person who's standing in front of the judge or magistrate subject to this potential eviction and having to leave their home, they're the ones who get to vote and elect the officials that hear these cases. And everybody's got to be cognizant of that. I don't know how it probably has some shaping involved, but I wouldn't say that it's going to be, it doesn't change the whole thing, but it is part of the landscape of this type of law and area. And I would probably venture to say all your clients and all my clients would much prefer these tenants to pay the rent and stay in the house than have to go through the eviction process as is generally seen to be a last resort.
Yeah, that's usually the case. I guess one last thing. I'd like you to get your crystal ball out and just kind of say, hey, what do you see happening over the next month, 3 months, 6 months, 12 months? Is there some things that maybe will never go back? They keep on talking about, certain aspects of COVID we're never going to change. But in the legal setting, could you break your crystal ball out and perhaps give a few thoughts anyways?
Well, I'll give you a few speculations on my own personal, uh, you know, perspective of what's going to happen in the next 2 to 6 months, at least in the landlord tenant realm. You know, my gut feeling is that the CDC eviction moratorium that's set to expire on June 30th will not be renewed. Now, I'll probably be kicking myself when it is renewed, but you know, there's been recent changes in the CDC's masking requirements and other sorts of things that have come out in the coming days that kind of undercut the justification for the moratorium, which was to prevent the spread of COVID. You know, and now the CDC is basically coming out and saying you can unmask if you've been vaccinated, you can do this, you can do that. So for them to keep a moratorium in place under the guise that they're stopping the spread of COVID, I think will be hard pressed for them to do. I think local courts will try to use their administrative powers and rules to make evictions more difficult still on the ongoing basis. That local courts are going to use this past year's experience and past year's rules that came out to help justify further difficulties on landlords going forward.
Yeah, that is concerning, but hopefully we can not have too much or be a bit ahead of it on our side. That's pretty much it on my side for questions for you guys. Did you guys think that there's anything else relevant that might be worth chatting about?
Andy, this is Richard again.
Yeah.
One thing that has taken effect while COVID has been going on, but wasn't directly related, was that Cleveland, the city of Cleveland instituted a right to counsel ordinance that provides for free legal counsel for tenants that qualify. Usually that means that the tenant has a minor in the household. And if that's the case, they'll be provided free counsel through legal aid. That is not going to expire as a result of any of these COVID restrictions being lifted. That's going to be the case moving forward. Those cases are a little bit more involved. So sometimes they get drawn out. Other times, working with legal aid gets the landlord their money in an expedited fashion because they're able to tap into resources and push the various agencies to get those checks out. So, but that is something that's going to be sticking around.
Sure. That makes sense. That reminds you of one other thing that I've noticed. We're seeing a lot of the courts do something which I think is innovative and great, which is online and Zoom court sessions. Obviously, there's some downside when someone's making a serious life decision for you, and you can't look them in the eyes. So, but do you see that continuing to happen?
Andy, that was going to be the other note that I was going to make. I will be very curious personally to see which courts go back to live in-person hearings and which ones continue the Zoom dockets, because there are pros and cons to both ways. Obviously, yeah. It's better not to have a congested building where everybody's standing around and under any circumstance. But you obviously lose the ability to meet face to face with your tenant, go out in the hallway before the hearing, and try and work out a deal. Sometimes that encourages parties to enter a breakout room in Zoom or whatever, Skype, whatever you're using, and come to some sort of resolution. I don't know. I wish I could tell you. I can tell you that the court got quite a bit of grant money and things when this all was going on that allowed them to put in place those capacities. So I might be surprised to see them just abandon that now that they're all in place. The infrastructure's there. Yeah. We've worked out most of the logistical issues in many of the courts. We may see that. I think what you probably will see is that some courts will keep that for some dockets and some types of hearings, and maybe not for others.
Sure. Yeah. That makes sense to me. It's
and
very,
I got
very interesting.
One more quick thing for you, Andy, and just to kind of put it out there for people to investigate if they're investing in the Cleveland area too, is a couple of things that have been hitting local jurisdictional ordinances lately, partly due to COVID and partly due to the ever-changing landscape, is they're instituting right to pay defenses to evictions, which basically say if you're being evicted for not paying the rent, if you have all of the rent money at or prior to the hearing, the landlord will be forced to take it, and they won't be able to evict you. It'll be an affirmative defense. Now, that's probably great in 99% of the evictions. Sometimes you will get an eviction where the tenant is, causing other problems, but also happens to miss a rent payment. And that ordinance could come to prevent that eviction. And then the other ordinances that you're now starting to see in local jurisdictions is a source of income discrimination ordinance, which basically says you can't pick and choose tenants based on their source of income, which is basically those, rental advertisements that say no Section 8. Those
Sure.
are being opted in some of the local jurisdictions around here, and that's kind of been the trend, I think,
Yeah.
across
Well, I
the
know
country.
South Euclid and University Heights. I suspect soon that's going to happen. In others, I don't know of any other cities right locally other
Um,
than those two.
Lakewood has just
Okay.
passed it, and I believe Akron has just passed a source of
Okay.
income as well.
And I've been seeing some news. I'll add to that. I suspect you're gonna. I think it was Cincinnati that if they didn't require it, they were discussing that law to require that landlords accept alternate forms of deposit, such as bonds and things like that. So I would not be surprised if that starts getting packaged in with some of the tenant friendly legislation
Yeah.
as well.
Andy, there's only one more thing that I might reference here. Earlier we had discussed the interim rule under the Financial Protection Bureau.
Mhm.
It's not just the disclosure language that's required. It also expressly prohibits landlord or their attorney from misrepresenting whether the tenant qualifies under that under the moratorium. So in those cases, I would just caution landlords not to get into that back and forth, and
Okay.
provide them perhaps just the link, the disclosure language that says here's where your rights and that are stated. You can go get your own counsel if you need it, whatever. But it's a trap for landlords to fall into if they find themselves saying that, well, we don't think you qualify for reason A, B, or C. So
Sure.
I avoid that issue if possible, because it could constitute a Fair Debt Collection Practices Act violation.
Sure. That makes sense. And by the way, again, we'll provide that. Just reply to the email on this webinar, and if we don't send it out directly, and we'll go ahead and provide that, which has been generously prepared by Lieberman, DeVorn, and Dowd. Okay, well, I'm going to move on to the next section here. If you guys don't have anything else, any other thoughts, closing thoughts? Do you have anything else?
I think we're good at it. We appreciate your time, Andy.
Okay, absolutely. So I have with us Ram Pinta. Ram is the iron-fisted, velvet-gloved collections ninja at Realty Trust Services, which we're a real estate brokerage that does property management. His claim to fame is that he is so good at his job that we have people we are evicting that are giving him 5-star reviews and mentioning his name online. Ram, let's talk a little bit about collections from a communications and administrative, more non-legal perspective. Now that we've covered the legal section, I want to hear kind of like you're down and dirty. Like, I want you to spill the beans for us and really tell us more, tell everybody here more so that they can either use it to evaluate their own management company, understand what we do here better, as well as possibly get some tips that if they're self-managing for things that they could do in terms of collections.
Yeah, sure,
So,
definitely, Andy. Love
so
the
when,
nickname, by the way.
oh yeah, absolutely. Iron-fisted, velvet-gloved collections ninja. That is a name. There's
Old
more
boys
stories than
love
what we alluded
ninjas.
to there. Yes. So when does the collections process start at Realty Trust Services, Ram?
Okay, so well, basically every month, by the end of the month, 5 days before we begin with the next month, an automatic reminder goes out for all of our tenants. Just to let them know, I mean, we assume most of them will be already planning on pay the rent prior to the first of the month. But in case they aren't, or they just are missing the date, or we need to remind them for any reason, this automatic reminder goes out 5 days before the month ends, so they have a heads up.
Yeah. Can I add in there that can I break in and just say that I think so many people have gotten an expectation that rent's not due on the first because honestly they're not going to get evicted till later in the month, even if you file earlier. And so often there's a grace period, and so people say, well, it's not due on the first. And just to make a friendly reminder that it is due on the first. And I know at times when I've done that reminder years ago when I was doing it, I would even say, you know what? I used to rent, but I own a house now. And we have our payment set up to go, a week and a half previous to make sure we're never late on our mortgage. And that's a kind of a way to think about it that makes it just easier. If it just happens automatically, it comes out of your bank. So we encourage people to set that up and just think about, hey, it's due on the first, and why don't you do it even earlier? Because this is where you live, And so we're trying to encourage people to have better habits, kind of as a word. I think it's a public service announcement. It's a way of trying to move people to think differently and better about their financial lives.
Yeah, definitely. Actually, I think this has worked great for us, at least for the properties we've managed for the past couple of years. I've noticed that at least half of our tenants actually do prepayments. They do have the ability to set up those auto payments to kick in prior to the first of the month. A lot of them do it, but a lot of them also do them manually. And I actually try to go through this prior to the first, just to take a look at everything that has been already been paid for, um, have a general idea of how many tenants we're getting in before the end of the month, their rent. I think this is a great take on how we can educate the tenants that we're working with, how we can adjust at the same time to sometimes this is also useful for tenants that actually do have really, really bad schedules with their work, crazy end of the month. We have nurses, we have a lot of people in different types of jobs, and these reminders are also useful for them.
Yeah.
Things can get a little bit crazy.
Sure. So, okay, so we've talked about when it starts, which is really before you have to collect. The setting the expectation is really big. Like on the first of the month, if they don't pay or late, so what happens after that? What do we
So
start doing? What do we reach out? All the rest.
So I would like to add something before that here,
Okay,
Andy.
sure.
There's a little bit else that I try to do before the first of the month, and especially on the first. On the first, well, it's usually going to happen anyways. But what I try to do is I try to stay as available as possible. Let's say the first of the month is on a Sunday or Monday, right? That you will usually get a lot of correspondence from the tenants, typically letting you know that they're going to be having issues with their payments, or let's say they are having this weird bug with the platform or something like that, or they need help pulling a partial payment that is very, very close to the total amount that we ask for rent, which we don't normally do. But if it's a very specific situation, and they are only missing, a small fraction of the rent, we can do that. Of course, it depends on the case, but we could make a judgment call on that. So there are very specific situations that tend to come up right about, right as we are reaching the first of the month. I think the best way to deal with this is to become as available as possible for all of them prior to the first.
Mm-hmm.
Otherwise, uh, the first comes and everything starts going faster for both them and for us. There's a lot of, claims, inquiries, everything coming in. Sometimes, if, for example, if it's a weekend, they take the time to go through these things, and if they don't get an answer, then the week starts and they are suddenly distracted by work, family stuff, everything else, you know. So I think it's
Mhm.
always better to be there, to be available, in case they're having some sort of issue with the payment. Any questions, you know, I don't know anything about, hey, why is this fee here? Why am I paying for this? Why did maintenance add this to the ledger? I think it's always best to be there in time before it gets a little bit more complex.
So what you're really saying is like, just like we already emphasized, communication is important.
Yes, always.
It's easy to have a tenant that's maybe upset and just not, but that just makes it worse and also reduces likelihood of getting paid if they don't understand why they're
Yeah,
paying what they're paying.
yeah, definitely. I think a bad day can snowball into a terrible month for the interaction between the tenant and the company.
Yeah, makes sense. And I would say, by the way, you know, as we've been doing this for over 10 years now as a third party, I've bought my first investment property and have had many rentals um, over 20 years ago. But you you start to see how important it is, you know, to have good communications with your tenants. I've done it many ways, but over time we've discovered you have to be available, you have to respond, even sometimes when you're uncomfortable. That's part of, you know, finding experts, people who are good at it, you know, who have the right personality to do it. Not everybody does. So let's focus back on the timeline. On the day two, what are we doing?
So day two is we're still stuck getting back and forth with tenants. Some of them are giving you notices that will be paying a little bit later. They are asking for, you know, authorization to do that. They are trying to give us information. Day two, automatically we add our first late fee to their ledger. We have several fees throughout the month that are correlated to the collections process. This is the first one. This is the one they are most familiarized with already. Typically, we want to let them know. Let's say we're bringing in a new tenant for not a new tenant, sorry, a new property that already has a tenant. We need to make it very clear that there is no grace period with us. We need to have rent paid by the first. If we don't, there will be a $35 late fee on their ledger at the beginning of the day on the second. So this is where a lot of inquiries come in. A lot of people try to get back at us, get back to us and just, hey, why is this fee here? I talked to the owner before and I was supposed to get a grace period until the third or the fifth
Yeah.
or something like that, right?
And
Right.
regarding fees, our company mantra is growing prosperity. And teaching them to have a habit of paying on time, to me, is like the best thing I can do for a tenant. Um, because that is like the number one building block to like moving up in life and being more responsible. And so we all want more responsible tenants. And so it starts right at the beginning with how we frame and set up things for these tenants. This isn't about just something that we're doing to punish anybody. It's the fact that we set expectations and we're going to try to help you meet those. And if it's not there, you're just going to say, well, it's not important. You know, it doesn't matter. I can pay it as late as I want. And before you know it, they get themselves into a real issue because they don't believe they need to, and then they don't set their life up to make it happen. Whereas if they understand this is an expectation, they can say, you know what, maybe it's time, instead of having this fee every time, to get I need to prioritize this rent payment, you know, and I'll not pay something else that doesn't have a fee attached, and it really doesn't matter, you know. I'll wait on the cable bill. I'll, you know, and maybe I'll take up an extra couple hours so I have some reserves, right? So I'm trying to get people to think that way because I believe it's in the best interest of of the tenants to learn responsibility, um, as well as uh, the owners that we manage for.
I completely agree with you there. And I think the most important thing we can do at this point, for example, if we have a new tenant coming over from different management or a new tenant in a property that we were already managing, it's really important to explain all of these fees to them but not putting them as as a threat or something like that out there. Just, hey, listen, I know you're new with us. I would like to, on behalf of the collections department of Realty Trust, I would like to go over these fees so that you understand how they work. My goal is to avoid you having to go through any of this, but I would like for you to understand them, because if this happens, basically cause and consequence, but without adding anything emotional into the mix. Like, just, this is how it works, and I would like for you to understand it.
Yeah.
This is how we could work everything in the best way possible,
Yeah.
right?
Well, it seems so much less fair when you get hit by something you're surprised by it. I remember in a former life, I got a bank fee, you know, and it's like sometimes it just seemed like honestly I wasn't that organized at that time, and I pulled the money out of my ATM, not realizing that something else was coming out. Well, no, actually, I pulled it out. It wasn't there to pull out. They let me pull it out, and then they charged me a fee. And I'm like, guys, it doesn't seem fair. There's a sense of fairness, and people have to understand. Like, if you just tell them up front, suddenly there's not a kind of animosity about everyday operations. Whereas if it's like, oh well, that was a surprise, something else like shit, like, geez, guys, what are you doing? And I really was pissed at that bank. I think I ended up changing. It was Fifth Third, I believe, like, because they let me do it, and then they charged me a fee. And I'm like, there wasn't even any money. I thought there was, but there wasn't. And you let me do this, and now you charge me a fee. And so at the end of the day, I think we're all okay with a lot of things if it's just explained to us. If we understand up front, hey, this is what's going to happen, don't do this, then we're like, oh, okay, that makes total sense. And so we try to have a collections process that makes good common sense, and then we explain it to the tenants so they understand, hey, this is what's going to happen.
Exactly. Yeah. I think it's our job to make it as clear as possible for them, as it is our job to collect for our clients. It's equally important.
Yeah, and that's a hard balance to follow for a property management company. Like,
I think it is. I've received actually feedback from tenants that were under different management about how they dealt with their previous collections departments, and I picked up a couple of things from that. I try to focus on what tenants generally perceive as hostile or as a bad service in general. And it's always good to learn from those mistakes that you were not doing yourself, but you can learn
sure.
from those, right? It's their
Yeah.
feedback, and that's always,
Yeah.
I think it's valuable.
So we said you were velvet fisted, and indeed you are. The thing that there's a, like I said, there's a balance we walk, but ultimately we believe it's in the best interest to treat tenants respectfully, because it's free, and then it helps. Ultimately, your biggest cost is going to be vacancy. Any landlord, that's their biggest cost. And if we can do anything, and I think we'll do another seminar on this, a webinar on just what can be done to reduce vacancy. But this is one of many things that we have buckled down on, and most of the reviews are from tenants that we get. And I believe we're one of the better reviewed property management companies. Most of the reviews are from tenants. Many of them are mentioning RAM. Um, but the point is that it's free. Respect to offer is free, and it's one of those like kind of unseen value adds that owners get. And if you are the owner and you are the collector too, just remember that even when a tenant's being unreasonable, there are almost always a way to show respect and come alongside them.
Yeah, definitely. Basically, when a tenant gets this late fee on the second of the month, the reminders about the pending rent plus the fee will keep coming pretty often from our system automatically. However, I try to reach out to them out of automatic reminders. Maybe a phone call, maybe an email, depends on what I generally perceive to be as what's the tenant's best way of communication for them, depending on their job, their schedules. That can be a little bit tricky, but you get to know most of them, and you get to know which ones tend to fall behind more frequently. So that's really important. Between the 2nd of the month and the 5th of the month, we have this period of time in which they keep getting those reminders. They don't get any other fees. They just get the first late fee and they get those reminders, and I try to work with them as much as possible. We try to get as much feedback on their situation during this period of time. And I always try to remind them of the upcoming 3-day notices. The 3-day notices take place on the 6th of the month, typically. Sometimes we change it a little bit depending on where in the month that date actually lands. For example, if it's on a Sunday, we don't deliver those on a Sunday. We try to do Monday or Saturday. The 3-day notice also has a delivery cost attached to it. It's also a fixed amount, and it only will be charged once. So basically, we go from
Could I add right in there? The 3-day notice is a notice that gives someone 3 days to respond. Okay.
Right.
The day count on that varies court to court. So sometimes they include the day, different courts go differently. Generally, the courts don't accept a weekend as one of the 3 days. Many courts do not accept the day it was delivered at all. So even if you deliver it on Monday, that doesn't count.
Right.
And then the last day is not counted. Like it has to be one more day afterwards, and then you're allowed to file. So it ends up oftentimes being similar to a 5 to 7 day notice, depending on the court. Just to be clear,
Okay, yeah, the language actually states that the tenant would have 3 days to respond to this notice. It's basically an eviction notice, and they are basically free to respond to us at any time to settle their pending rent. We can just help them get back to normal, which is always our first and foremost goal here, to avoid vacancy, to avoid filing an eviction. But they also have 3 days, 3 business days to just vacate the property. We try to give them a little bit more leeway here. For example, if the notice was delivered on a Monday or a Friday, Saturday, we try to wait for a full business week after it was delivered if we have to file an eviction, just to make sure that enough time has passed. So after this has been delivered, we need to follow up with them. Typically, this is the first official warning. Nothing is filed at this point, but this is the first official warning that they might get involved in a legal procedure by us filing an eviction if they don't get caught up. We use very specific language that is required from us in our 3-day notices. However, we also send them an email at the same time, actually before we deliver the notice, to let them know that this is a requirement, but we are not looking for them to vacate, unless this is, of course, a very specific situation.
Thanks for sharing that, because I was gonna try to get to that. If you read a 3-day notice, and anybody who's a part of this seminar is this webinar is going to get an email with the updated with the COVID guidelines 3-day notice. The truth is, when you look at that, you're like, as a landlord, I'm like, well, wait a minute, I don't actually want you to leave, but like the notice has specific legal terms, and it basically says get out, you know. And you can only imagine, as a tenant, they're like, well, wait a minute, I'm only 5 days late. You just want me out like that? Like, is that how it's going to be? Like, come on, like, I've been a tenant for a couple years, and just, like, so unfortunately, the legal, there's not a whole lot of room to soften the statement itself. But you made the point, and the point is that ultimately we want people to stay and pay, because ultimately vacancy is expensive, and so proceed on, but I just wanted to explain that.
Yes, I think that's a very important part of what we do here, and it will all peek into those reviews you were talking about earlier. I think this is the first part in the one of the most important parts in the at the beginning of the collections process, in which we need to go and say, hey, I need to do this. This is our procedure, but we want to help you out as much as possible within the bounds of this procedure, right? I think this is where we need to go ahead and, like I said, we send that email, we explain to them that we don't really want them out. We understand that they might be caught up with some sort of issue financially or anything else, but we want them to get current, and we need to talk about this. We need to have a discussion, lay out the details of what exactly is going on, what we can do to solve this situation, if it can be solved swiftly, or if it's something we can touch back every week, see what we can do, how it evolves. That this is where we need to get hands-on into each specific problem with each specific tenant in order to avoid having to file an eviction. As Darren and Richard mentioned before, filing an eviction typically is last resort. We want to avoid vacancy at all costs. And this is obviously for us in order to protect our client's business. But at the same time, we need to let those tenants know that we also care for them. We want them to stay in their homes. We want them to enjoy their homes. They need to understand exactly how the process works. They need to understand the consequences, but they also need to know that we are trying to do the best for them and for our clients as well. Of course, in our capacity as managers, our clients' businesses come first, right? So they need to know that we can work this out. And there are several ways we can work this out, especially right now with the COVID situation and the rental assistance programs and all of that. There are several avenues we can take, but we need to be very clear about this. This is where we need to enforce communication and try to stay in touch with the tenant as much as possible, up to the point in which either they get current or we have to file an eviction.
So let me ask you a question. What's the soonest we will file eviction, and what's like the latest really in a month that we would want to file eviction?
So typically, since we need to wait for around a week after we delivered those 3-day notices, and they are typically delivered on typically it's on the 6th of the month, unless we want to deliver a very early 3-day notice for a very specific case that we know it's not working out. Maybe they already have past delinquency and the owner has decided they want to file as soon as possible in the month. That might be an exception, where typically they are delivered on the 6th. We tend to file around the 14th, 15th of the month. We try to make sure a full business week has passed after this has been delivered. And the latest we file typically is by the end of the month, basically. This depends usually on communications that we have with the owner of the property directly. Sometimes they want to give a little bit more time to the tenant before we file. Sometimes maybe they already sent us a payment. They sent proof of sending that payment. We want to check if this payment was good. We ask for certified funds. For example, if there has been a bounce electronic payment in our system, we ask for certified funds, which is a cashier's check or a money order delivered straight to our office or mailed to our office. If that's the case, we need a little bit more time to check on the payment to see if it's good, if they deliver it. I usually try to ask them for, hey, can you just send me a picture that you delivered the money order, just so I can have a reference, just for some peace of mind on our side.
Yeah.
I don't do that I don't ask them to do that as as a compulsory thing, but I try to ask this politely of them.
Yeah. Well, obviously there's an understanding that it's within your power not to delay, and
Yeah, exactly.
so that hopefully they understand that. Interesting. So, what do we do in terms of interaction with the attorney after we file on our side?
Okay, so typically this usually depends on the case. There are very straightforward cases. For example, pre-COVID, we had a lot of evictions typically went very swiftly. So we file and we usually get updates from our attorneys, in this case, LDD. Um, we get confirmation of documentation having been received, and I try to confirm if they have already filed the case. We check on the online docket as well. But if there's a delay of some sort, for example, I do know that typically we will get, under normal circumstances, outside of pandemic, typically we can get a hearing scheduled about a week, maybe 10 days after it has been already filed, after the process has been filed. So they send confirmation that it has been filed, and I kind of measure out those timelines. If more than 7 days have passed and I still don't get a hearing date for this case, I try to reach out to them, try to find out what exactly is going on with this, why it has been delayed. Typically, some cities have different, slightly different timelines, but we go back to between 7 and 10 days in order for us to get something scheduled under normal circumstances. After this, we get confirmation of the hearing getting scheduled. I would normally be in touch with both our attorneys and the staff member that's going to attend this hearing for us. So as soon as we receive a hearing date from our attorneys, we confirm this date, we schedule, and we are already in touch with the staff member that has been appointed to attend these hearings and also takes care of delivering these 3-day notices. For more straightforward hearing process, eviction processes, we just give a basic breakdown of what the tenant owes, a copy of the ledger, the lease, and I try to give the staff member a short briefing on this case. But they are typically very straightforward when it's not pandemic related. For pandemic related evictions, it has been quite a ride, honestly. And a lot of these cases are way more complex than your usual eviction, mostly because there's a history of everything that has been worked on with the tenant, including rental assistance program applications, confirmation from these programs. Sometimes it's even more than one. Maybe proof of whatever situation the tenant is going through that they have sent to us, going back and forward with the owner about this case. And so all of this needs to be properly disclosed to both our attorneys and the staff member that's going to attend the hearing.
Makes sense. Do we typically, are we typically trying to actually stop the eviction? Do we typically want to keep the tenant if they can and will pay?
I will say that 99% of the time we want to keep the tenant. We do our best to facilitate them getting current. For example, at times, and this needs to be discussed very clearly with your client, of course, but at times even a payment plan could be set in motion. Maybe we allow the tenant to make a down payment for half the amount owed, or maybe even a little bit less. But yeah, we need to work with them.
I would say I try not to do a payment plan that does not include a written judgment through the court, so that we don't have to restart eviction if they don't fulfill their plan. So I very much prefer getting the eviction with the agreement that if they pay X by Y before the move out, that we'll cancel. And that way we already have it. What do you think here?
So that's actually one of the rarest of things that actually happen, a payment plan outside of court. Typically what we do is we just try to work with them as much as possible. Even if it has already been filed, and even if we already have a move out date set by the court, it's really important to let them know what exactly is going on, to the tenant and the owner.
But
at the same time, always let them know that at any point in time, if they manage to get current, if they pay everything they owe, including, and this is sometimes negotiable, but we try to include in this our lease reinstatement fee
Sure.
that we add to the ledgers when we initially filed the eviction process. If all of this is paid up, typically that's our offer. We will just call off the entire process, even if we have already been approved with a move out.
Sure.
Our top priority is to keep
Yeah.
them in the property unless the owner has basically actively decided that this tenant is not only delinquent in their rent, but is also causing other issues that they really wouldn't want to deal with
Sure.
anymore.
Yeah, and that
And
obviously is the big factor. That's the big deciding factor, is if there's other issues. And I'll jump in here real quickly and
okay,
make a point that a lot of owners, we've had owners and they see like one little issue, like, oh, the tenant's not a good housekeeper, or maybe they've, you know, dirtied up the wall or something we have to paint, or, and they think, well, let's give them notice because this is we don't want this tenant. And normally I really counsel owners, listen, vacancy is expensive. Do you, this tenant has done enough damage that if they do more damage in the same kind, now it probably depends a little bit, and it also depends if it's multi or single, but to an extent, it's gonna cost the same to paint a wall, whether it's mildly nasty or really, really nasty, right? And so if they're there and they're paying rent, or they can pay rent, or they can catch up, you don't necessarily want to evict that tenant, because that means an immediate expense to you and a questionable, if they couldn't pay the rent in the first place, that you'll collect from them. And versus you being able to say, you know what, yeah, I'd prefer that they continue to pay rent for the next 5 years, and if I have to replace the carpet, it was already kind of figured in as a business expense at that point in time. It would have been needing to be replaced, you know, the full 7 years anyways. That's the lifespan of a carpet anyways. So you make them pay, you know, for the damage by just keeping them in and paying the rent, you know. And frankly, we've even used that as leverage on renewals, where I've had conversations saying, hey, um, you know, we did an inspection. There's going to be some damage that you're going to be assessed for. Why don't you just stay here? And if you stay here long enough, you know, I mean, you essentially, you can delay the cost of having to kind of pay your repairs. I mean, the damage you've done. So I kind of encourage that highly, in general, and really try to. Some landlords, they reacting emotionally and they're not thinking through. And part of what we're trying to help on the landlord side in terms of representation is, let's look at this as a business. Let's just put it as a formula. Not only is this a nice business that really provides something amazing, like families are living in your houses, so and at the same time they're creating wealth for you long term, but you can look at just look at the numbers here. Like, the numbers are so much better if you just keep this house, keep somebody in the house paying their rent, than just because you feel bad about the fact that they're not keeping it up like you would, not that you're going to cause undue financial stress on yourself. So we really push that.
yes, I think this is where history of each individual tenant comes in as well. I think it's really valuable when counseling our clients. If, for example, let's say this tenant just began getting behind, uh, every couple months they get behind, right? And they've had to possibly be very close to filing an eviction twice or thrice. However, this tenant has a great history in terms of payments prior to that, or they keep the property in perfect shape. You know, these things can go back and forth, all of those little details. And it's really important for us to be able to include all of those angles. I think the more information we can feed our clients, in terms of the condition of the property, the history of the tenant, all of those little details, incidents, lack of incidents, everything, the better they can make an informed decision about how they want to move forward, even though at this time it's really doubtful how it will be turning out, right? I can tell you, for example, there's a couple of cases that we actually have. We have two property owners that even if their tenants get behind 2 or 3 months, they will always tell me, and I do try to let them know, hey, maybe this is not a great idea. This is getting worse. They are getting behind a lot. And they go like, okay, still, I don't want you to deliver a 3-day notice. I really don't want to file an eviction in this tenant. And these are very, very specific exceptions. Like I said, it's only been a couple of cases. And I can tell you that these tenants are completely current right now. So they have made the decision that they want to incur that risk. And in these cases, it has worked out.
Yeah.
But sometimes it's a little bit more difficult than just how many times they have gotten behind. This is where we need to basically incorporate the whole vision of our company and how all of our departments work in tandem to protect the interest of the owner.
Yeah, absolutely. So do we typically go to second cause? We talked about second cause and what that was in the first section here. Do we typically encourage our owners to go to second cause?
Going to second cause for any of our clients does imply a little bit more expense that they would normally incur if they only went to first cause. However, in most instances where a tenant actually does move out due to an eviction, our clients do want to recoup some of that damage.
Sure.
I would say this entirely depends on what we find in our move out inspection. It's our duty to show those reports, give those estimates to our clients. And maybe there will be an instance in which even if the tenant did not actually pay, let's say, only last month's rent, but they left the property in an excellent state, it might not be completely worth it to pay those legal fees and pursue a second cause for only 1 month's worth of rent. Of course, it depends on the amount of rent that you're getting for the unit, but mostly what maintenance finds is what makes the difference. I can definitely tell you that the vast majority of non-paying tenants tend to leave the property in a really, really bad state. So the vast majority of these evictions do end up in a second cause.
Sure. And I will say that there are other alternatives too. Sometimes you can make contact and just create a monthly payment up front, so you don't need a judgment. Obviously, it doesn't mean you don't need a judgment because they might violate their agreement. Sometimes you can give it to a collections company and report to a report on their credit, and then eventually, who knows, things could be restored. They could be better, and they want to go buy a car and there's something on their credit, right? So those things kind of hang out there. There's other collection strategies as well, but what I will say is we're not a collections company. We offer collections when it comes to tenants being in a house, but afterwards it's actually a very different thing. It's like an unsecured debt or something like that. It becomes there's a whole set of things that are done afterwards that you can do if you don't have a judgment, or if you do have a judgment, either way.
Right, and having said that, actually, it's actually very important that you just said that we don't normally do collections after a tenant has left. However, I do try to communicate with them as much as possible. Try to let them know what the repercussions of debt of a certain amount will be for them. Maybe their credit, collections agency trying to collect from them, etc., etc. They need to understand that this will cause trouble for them as well as future tenants in a different property at some point. I try to use this as leverage in a way, but I'll also try to give them friendly counsel in terms of, hey, you could settle this, you know. So how about we just, if you're able to right now, maybe we can try to settle. And it is very rare, but we have definitely gotten payment for a tenant that has been evicted. I think it has been, of course, this is very super rare. It has been twice or thrice, I think. But it does happen. There are tenants that will follow this train of thought that you are presenting to them. And there are definitely also tenants that maybe they are not able to pay the rent right now. They're getting evicted, but they are worrying about their future and they are worrying about their history in terms of their ability to rent, you know. So I think it's always best to offer this option, offer this information, and try to recoup as much as possible, even if that's not something that we do specifically as a company, before we send this to a collections agency or anything of the sort.
So, Ram, can you tell me what is the cost to show up to court for with our expert witness?
Okay, that would be $150 for us to show up for first cost.
Okay.
It's really important to know that the first cost and second cost are both included in the initial filing that our attorneys do for this. But if an owner does choose to go to second cost, we would still charge for that additional visit to court.
So we've talked about the collections process from our perspective, what we do, how we think about it. Obviously, the last year, that's been an anomaly, right? And you were doing it quite some time before that in terms of the collections and doing a great job. But what have we learned to do? What are some lessons? What do we do in terms of the pandemic? How are we helping? I've seen some amazing things happen. I think we saw a 5-figure check come to pay one tenant's balance once. Like I think we've received over $100,000 of government funding at least. I didn't do the full numbers, but I know we've received a lot of checks from the government still for the pandemic. So can you tell me a little bit more about what you do, how you work this out, how it's different than before?
So yes, at first it was kind of tricky. We were in the middle of a storm last year, honestly. Um, Basically, our hands were a little bit tied for a few months. We weren't able to do much other than filing and getting these evictions that we had already filed postponed. Basically, just the processes were completely frozen for a while. We needed to deal with this. There wasn't a way out via court at that time by mid 2020 due to the Federal CARES Act and then the CDC declaration kicking in. However, we did our best to, and this is also before rental assistance programs kicked in. We did our best to just try to handle these situations, basically tailor ourselves to the situation. Try to collect from the tenants if possible, try to work with them as much as possible. I will say that most of these cases were resolved without actually continuing with the eviction processes. There were a couple that were they just kept going for a while. We weren't able to go to any hearings at all. However, as things started to evolve, even with the CDC declarations in place, we were able to start reaching out to several organizations that we could rely on for rental assistance programs. For example,
What
I would say,
organizations did you use? What are the, I think there was like 4 you've mentioned.
so the three that we have leaned on the most, and the three I've been worked on directly with for the last few months, have been the CHN Housing Partners, the Council for Economic Opportunities in Greater Cleveland, that was just rebranded last month as Step Forward, and Eden.
Okay.
So
Do you find one of them is better than the other? Do you have
so
what can we kind of do to help tenants get this funds? Is there anything that we can help other than just kind of?
so the initial step to get this going for all of them is for the tenant to apply. So uh, therein lies also the big initial problem that if a tenant doesn't really care, which there are tenants that don't care, um, we cannot force them to apply, and we cannot apply on their behalf. So this is where we need to stay in touch with the tenants, try to express what we want, what we hope for them to do in these cases, but also try for them to understand that, hey, these organizations are offering basically free rent for you. You are
Yeah.
not able to pay rent. Why not take it?
Yeah.
Like,
Well, and by the way, sometimes it does go to, oh, we have to go to court and we evict. Well, they still have to sign their the declaration, right? That says they applied.
yes.
Okay.
It-
And if we get clear proof that they didn't apply, because we're always contacted if they do apply, they cannot send funds without contacting us and getting a declaration from us. So if we don't, if we didn't get that, we have clear proof they didn't do that. Okay. And so that is like the leverage we have to force them to apply. And we've had back utilities paid in addition to rent. I've seen them pay the reinstatement fee, late fees, um, and other things. It's actually it's impressive what I have seen paid.
So just so you know, typically they don't pay for water and sewer, which would
Okay.
be utilities.
Well, I did see it
Um,
happen on. I know I'm thinking of one where we saw water and sewer
yeah,
paid.
there are additional programs, like smaller programs, that these big programs actually channel those tenants towards to, so that they can apply for those utilities. However, the one we've been leaning on the most has been CHN Housing Partners, and actually the Council of Economic Opportunities in Greater Cleveland and Eden are working in tandem with CHN. I would say CHN is our initial contact for all of this, and then if they need a little bit of support from the other two, they go ahead and the applications get basically reviewed by all of the programs at the same time, and they reach a resolution in tandem for them to be able to actually meet the requirements for this assistance. Like you
Sure.
said, we've gotten payments for 5 figures. It was actually, I think we've gotten like 4 of those by now.
Hmm.
And these have been cases in which the CHN has been working alongside the other two rental assistance programs in order to meet these very high requirements of assistance. Um, these tenants were tenants that began having issues by the beginning of last year, and some of their cases were they weren't they didn't really find any resources to be able to pay the rent other than maybe a couple of partial payments over the course of several months. Then when the rental assistance programs kicked in, they applied, and some of those cases have been delayed for a while. They have gone on their reviewings and over again. I can tell you that for the more complex cases, that do end up in these big payments, I've had to resend updated information, documentation, and a breakdown of delinquency maybe 4 or 5 times to the same rental assistance program. Um, they do have a bit of a backlog, and right now it feels like they're catching up. But for the most part, this is why they were taking so long. So this is why they were requesting more information again from us. Hey, I need you to update me on the next month, please, because we won't be able to close this out right now. So, like I said, it has been a long ride, but in the end, as long as the tenant applies, which we do our best for them to do, we give them all of the information, the links, the contacts, everything. As long as they apply, we will get your rent back through these programs. The the only bit of uncertainty here would be the utilities. Some of these applications, even if there are side programs that are attached to these main ones, even if there are, they don't always get those utilities paid for the tenant. So in the end, they will ask us to compromise. accept the payment for the rent, which is usually a lot more than what the tenant owes in utilities, and try to work something out with the tenant.
Yes.
So this is basically the same process whether the tenant is going through an eviction or not. But we also need to keep the CHN, Eden, all of them informed on the fact that we are going through an eviction process. And this usually speeds things up. And I believe the council actually requires the tenant to at least be served a 3-day notice for them to be able to take their application. So they have very slightly different requirements, but overall, they're all very effective. But the CHN Housing Partners is basically spearheading this whole rental assistance movement for, I would say, since July, September last year.
Hmm.
They've been doing a great job, and we have been recouping a lot of resources for these owners. Um, it's really important to keep them informed of how this works and why these are getting delayed. The volume of applications from what I've heard from the case managers are insane, and they are really low on manpower compared to the amount of applications they receive every month.
I wanted to go into a little bit and just talk with you on how you handle after a tenant moves out, even if it just moves out normally, right? There's a whole process that we do, and it's very much collections related because a lot of times your tenant moves out, you're having to deduct a security deposit. There's timelines. There's a process. Can you tell us a little bit about that specifically in terms of the move out, what happens, what we do?
Yeah, sure. Okay, so after a tenant, this all starts when a tenant either gives notice that they won't be renewing their lease, or if for some reason we gave them notice that we won't be renewing their lease, and now we suddenly have a move out date, right? So it's very, very important that to start off, we give the tenant proper move out instructions. These move out instructions need to include basically everything they need to look out for in terms of how they need to, the state they need to leave the property in after they move out, as well as the information that we require from them. For example, their forwarding address, if they use a carpet cleaner, carpet cleaning service, we need the receipt for that, things like that. It's a lot of details, but we need to give them a very clear breakdown of everything they need to look out for so that when deductions come, they don't have any surprises there, right?
Makes sense.
At the same time, I I send these instructions and I try to follow up with them. Lots of lots of tenants typically have several questions about how exactly will X item that they modified at the property will affect them. Our general response to an inquiry like this would be you need to leave the property as it was when we gave you the keys. Otherwise, something might be applied into your security deposit deductions because it has been modified, right? Of course, damage is the most obvious one, but in the end, we just try to be as clear as possible with them. After they move out, our
Is there damage to the property that we cannot deduct?
so there's a thin line sometimes between damage coming from wear and tear and possible damage that looks like wear and tear but was caused by the tenant. This is something that we need to look out for, and I usually try to get with our maintenance manager about this when running deductions on these type of items. Um, I would say if it's not clear enough that the tenant did this damage and it's not huge damage, like let's say scuff marks, something like that, I would say it's not worth to pursue insecurity deposit deductions. We will, of course, add it as a deduction to the security deposit, but if there's a claim from the tenant during the reviewing of these deductions, I would say it would be in the best interest for the owner not to pursue that item. Anything that might be cause for doubt in terms of wear and tear, it's not worth the risk. Having to go to small claims court and basically generating an additional cost to the owner just for that item.
Sure. And let me just explain a little bit on that, because in Ohio, there's a number of rules on how security deposit must be handled, because it's just a higher duty of care when you're holding somebody else's money. And technically, the deposit is not the owner's money. It's actually the tenant's money held by owner or owner representative. In our case, normally we're holding that deposit in a trust account. Okay. And so because of that, because there's a kind of power imbalance, tenant doesn't have their own money, and honestly, the owner can just deduct whatever they want without a certain amount of regulation. Um, there's a risk that if you're found to have deducted something that you should not have done in the court, it's double the security deposit back. Okay, potentially the entire security deposit, double back. And if we collected a double or triple deposit, you could have 6 times a month's rent given back. You know, so there's a certain amount of risk in that you have to just really, it goes way past kind of like whatever you feel is like a hill to die on, and goes to like significant risk. And the other thing is that I mean, a really involved security deposit dispute in a court, I mean, you could potentially, like, if you want to fight it out and go back and forth and rack up time, legal time and our time and everything else, it would be no problem to have a court case where you have to pay an attorney, and because suddenly you're getting discovery, you have to sit while an attorney says this and that, and everybody else has to do discovery, and the attorney is sitting there this whole time. 10 grand would not be out of line. And so so you're trying to deduct $500, or $1,000, and then you have unlimited attorney's costs to defend a tenant, and you have a court system that's generally a little bit favoring a tenant just because for political reasons. And so you have to kind of like, we fill these things out and we justify everything we can. We have very detailed reports with detailed pictures. I've had attorneys say, wow, I wish all my clients had reports this way. But at the end of the day, a picture only does not tell the whole story. You could, it just doesn't. And there's a whole lot of judgment. And the law itself does not even clearly define what additional wear and tear. So there's all sorts of standards that you could choose to go by that are either very tenant friendly or owner friendly. We tend to go on the owner. We tend to, favor the owner because they're our clients in the process. But then then we're cognizant as we negotiate, and it is a negotiation of what the risk is. And sometimes we just we favor the owner just because we know we're going to have to negotiate anyway. So we're going to give something to the tenant. Ram, I've seen you do some incredible negotiations with these tenants, and I'm just surprised. Like, wow, I can't believe we got out of this without a big mess.
I think a big part of that is what I said at the beginning. The first interaction with a tenant regarding collections,
Yeah,
it just starts from there. We need to let them know that we are doing our job and we are not being biased at all. Even if that would make sense, because we have clients to protect. I am very clear when we go into deductions that I go specifically by facts, by our reports, by the pictures, by the notes, by what we had before and what we found after they left. So even if we have a great relationship, and let's say even the tenant already gave us a 5-star review on Google, that goes out the window. I need to go by the facts, and you need to understand this. Of course, I am very polite when I talk to them about this. I try to be as understandable as possible if they have an inquiry at that time or they just snap out at me, you will get yelled at times. But but everything, it can be talked out. So sometimes, let's say we get a tenant, security deposit deductions, everything looks okay, but for some reason, maintenance is charging them for something that they claim was already in that state at some point, right? It's very easy for us to just go ahead and show them the pictures before and after. Hey, you did this, so you're paying for this. But it's completely different when you go ahead and say, listen, I know where you're coming from with this. Um, I might, as a tenant, also be confused as to why they would be charging me for this particular item. But let me break this down for you. Okay, this is what your lease states. This is what we gave you in terms of the state of the property when you moved in, and this is what we found. Does this look like this was damaged, or does this look like wear and tear? And typically they will go ahead and say, okay, I think we can agree on something, right? Or yeah, like, but it's about the way you say it to them, about the way you relate to them. By that point, you are already a helpful member of the staff that is looking out for both them and the owner's interests, but without being biased. And
That's
that's the important
interesting.
thing.
That's
They
really
need,
that's very
yeah,
fascinating. So yeah, it is all about and I think we're able to be somewhat of an impartial third party. So like in negotiations, it's always a benefit not to have the right to say you know, not to have full decision making, right? Because
exactly.
then we can kind of say, well, yeah, I hear you, but we have two parties here, that have to make this decision, you know, and and you can get people to move a little bit because they realize that you're not actually the final decision maker.
Yeah, I'd say that's very helpful. But typically when negotiations go bad is because there wasn't respect on some side, or there was neglect on the way you were interacting with somebody. And sometimes that doesn't even matter. There's people that's going to just yell at you and say, hey, I'm going to suit you guys.
Yeah.
It doesn't matter what you say or how you treated them, but most of the time it does make a difference.
So Ram, I appreciate all the information. Is there anything kind of final that you'd like to summarize everything that in terms of collections that we do?
Informational emails and things that might be able to educate tenants in some level are always useful. Information regarding rental assistance, information regarding their options if they were to enter delinquency and they have already used rental assistance. Anything that might be used at some point as a tool to resolve a problem that hasn't showed up yet, I think it's always good to take the time to offer that to them and the property owners as well.
Okay. Well, Ram, I guess I'll just say I appreciate your time. I've actually learned something, and I'm glad that we did this. I'm glad everybody that could be part of this could be part of this. Like I said, I will be emailing out the COVID relief 3-day notice, and I'll probably send a bit more information. Feel free to request just more information what we've done to kind of reduce the total costs involved in vacancy. I'd be happy to share a bit more with that on that, and I think that's pretty much it. Everybody have a good day.